afternoon, everyone, and thank you so much for joining us this afternoon. My name is Sydney Warren, and I'm Managing Director of Bridgeford Advisors. Today, we're going to be talking about the HBO show Succession, not just because it's a great show, but because it really shows us what can happen when improper wealth planning is not used with large families. I'm honored to be joined here today by David Warren, and he is going to talk us through this entire story. We would love for you to put some questions in the comments, and we will talk through them throughout today. Bridgeford is honored to be the largest independently owned South Dakota trust company. Now I'm going to hand it over to David Warren, Chairman of the Board.
It is wonderful to be here again with the live stream event for our friends around the country and across the world. You know, it's amazing, the list of people and the friends that have signed up and that are with us today is it's humbling and it's heartwarming because there's so many people listening today, watching today that are help contribute to where Bridgeford has gotten over the years. And so we're humbled again of the position that we've ascended to, and very excited, as always, about big ideas. We love big ideas at Bridgeford, and I don't watch a lot of television, I have to concede. But this show, Succession, not only did it resonate, but it hit a real nerve for me. And we put our heads together at Bridgeford and said, well, how do we look at the show Succession and use it as a cautionary tale, if you will? And so we thought hard about the content, and we thought about the lessons learned. You know, for those of you who've seen the show Succession, you know it tells a really amazing story of an entrepreneurial spirit, an entrepreneurial person who started a media empire and was brilliant in many ways and amazing in many ways, but may not have done the best planning, may not have even been the nicest person, as some of the episodes illustrate. And at the end of the day, I think it's again a cautionary tale. It gets into ideas around what you can do, or well, I guess what it does is it points out areas of failure, and then we get into the ideas of how to avoid that sort of failure, and what happens when there's magnificent wealth and families, first generation, second generation, subsequent generations are not ready for it. So the framework is not fiction. I mean, this is written to translate. This conversation is written to translate real world trust planning issues into actionable strategy, using some anecdotal examples from the series. And for those of you who watched it, you know, as Sydney said, not only was it a great series, but I think it was very much written with a message in line. And I think really the thesis was that if not properly handled, extreme wealth can destroy families. And so we took that as a rallying cry, I suppose, Sydney, right? And we thought about it in the context of, well, how do we protect wealthy families from themselves with the power of modern trust law? And that's the theme for today, and that's what we're going to focus on. So we certainly encourage questions as much as we can. We love the interaction, and we'll get to them as we go. We don't have to wait to the end. And we look forward to a really fun, exciting, and dynamic conversation. So we're going to focus on modern trust law and how it's applicable. These modern trust concepts are applicable in virtually every aspect of the Succession series, and how if a lot of these, or all of these, in fact, were applied in some form or fashion, we would have avoided really what was a tragedy at the end. And for those who watched the series, it ended as a tragedy, in my view, not only for the family personally, but also in the missed opportunities to avoid so much of the calamity that hit the family in the first, or rather in the second generation in particular. And we're going to talk about all these concepts. And, you know, as we were preparing for this and thinking through the best way to have this conversation, this quote really hit me hard. And it's in many ways, I think, a guiding light of Bridgeford from the beginning, but maybe we didn't realize it. And of course, it's from Bono, and it's this idea that the future is not something to experience, it's something to manifest. I think if we think about what we're doing in our industry, and I know there's so many estate planners on today, thank you, and financial planners and CPAs and family offices, really what we don't want our families and the groups that we work with, we don't want them just to experience life. We want them to manifest. And I think that's what planning is all about. That's what we're embracing at Bridgeford. And this is what we're getting into today for the next 90 minutes or so. So again, questions are welcome. You know, we can't have a conversation, in my opinion, about planning and working with wealthy families and working with sophisticated trust concepts without embracing the reality of what is our world today. You know, there's so much change happening. We all live through and know the push for global transparency. The political volatility and social unrest is, again, something we can't ignore. This isn't a political statement. It's a statement of fact. I've said many times in the last year and a half or so, as a lawyer, I'm witnessing things I never thought I'd ever have to think about, which means we have to think about it in the context of the planning that we're doing for our families, unequivocally. And that's the message, that's the conversation that we need to have. Ongoing geopolitical pressure, it's the same concept, but also increased personal security risks for wealthy families. One of the biggest drivers of people coming to Bridgeford, and one of the most common themes of all the 400 or 500, that's a real number of people that are coming to us through our website, through our social media and digital media content, is asset protection and privacy, and how do they maintain a semblance of security. That's real. And it's more real now, I argue, in the last 18 months, perhaps, than what it was historically, because of the issues that we have to embrace. And regardless of what your opinion is of what's happening in the world in the United States, it's still an aspect of what a good planner does, which is we anticipate and we think and we're ready to move and act when we need to. And so the conversation around all of these ideas is something that we're very much passionate about at Bridgeford, and something that we really want to focus on with our families, and we're going to focus on today.
Before we move on, can I ask you, do you think that we would see something happen like the Corporate Transparency Act again, which obviously was a big concern for families? Do you think that would ever go through?
Thank you, Sid. That's a great question. I mean, we all know the Corporate Transparency Act was something that was attempted to be implemented here in the United States. It gets to the idea of security and the ability to protect one's privacy. We're going to talk about it a little bit later in the conversation. Privacy, I believe, is a fundamental right. Corporate Transparency Act, I thought from the beginning, went too far. I'm not surprised that it failed. I'm happy that it failed. I think it was overreaching, and I think collectively business owners and people who were doing the right thing in this country took a collective sigh of relief. To your question, Sydney, though, which is a great one, do I think there's going to be an attempt again in some form or fashion to push the boundaries of privacy, which, to be clear, I'm not advocating secrecy. I'm talking about privacy. And the answer, unfortunately, is yes. I do think there continues to be the battle cry for more transparency, and there's always going to be this balance, I think, between what is transparency and what is intrusive. And they're two different things, and I think we have to work hard and be very vigilant to avoid the too much in the way of the pendulum swinging into being invasive and intrusive into our personal lives, for sure. A big theme, not only of Bridgeford since 2010, 2011, but really of all modern trust law, is this idea of jurisdiction and why it matters so much. So we're going to talk about directly and somewhat tangentially the idea of why jurisdiction matters and how finding the jurisdiction with the strongest modern trust law tools is essential. And it goes back to the Roy family, and you talk about what happened in that in succession. The fundamental question for the planning that probably wasn't happening, or clearly wasn't happening, which is why there was so much calamity, was that I don't think there was even a discussion of a jurisdiction even before we start talking about trust. So there's a race. We know there's a race in the United States of who could be the most effective trust company, or rather trust jurisdiction. Top tier trust jurisdictions: South Dakota, Nevada, Delaware, Alaska, Wyoming. We're all in a race to provide the most compelling solutions from a trust planning perspective, and the ability to do the best for our clients around asset protection and privacy and tax planning, all of which we're going to get into in a few moments. Wyoming's talked about a lot. I continue to scratch my head a little bit on as to why, from a trust perspective, it's made its way up, because I don't think really even Trust in the States magazine considers Wyoming to be a top tier trust jurisdiction. But I can tell you, especially in the last edition of the Trust in the States magazine, that the other states are working to become a top tier trust jurisdiction. Of particular note is Tennessee. They were observed this past article about how they have may have ascended into the top trust jurisdiction. I didn't mention them here, but I do want you to look at Tennessee, as they have worked hard to capture parts of this market, and they have put some sophisticated laws in place that puts them on par, perhaps, with the top tier, and that's a neat development. We're going to transition into a discussion around how tax planning through effective trust structuring in the United States is so compelling. But it's interesting to me, before we get there, to consider this quote. Nobody likes the word haven. We've used it. I use it because the New York Times has used it, and the Wall Street Journal has used it, and the Atlantic and in Europe has used it. Whether we like it or not, or more importantly, whether regulators like it or not in the United States, we're considered a tax haven and a privacy haven. And in many ways, it's for reasons that I'm about to mention. But you go back to succession for a moment before we get into these ideas. It appeared, because of the lack of structuring and planning, and that was a theme throughout the show. It seemed that there was a void there in terms of that kind of planning. And of course, we can't know for certain, but there were certain scenes throughout the whole series where it appeared to be a real haphazard and very poorly designed wealth plan at all, and which is evidenced by that one scene, for those of you who know the show, where there was an old trust that somebody had scratched out the name of the main beneficiary and replaced it with the name of another child. That denotes to me that there wasn't very effective planning going on, and which is a great way to sort of begin with what has become modern trust law. And I love this conversation around the dynasty trust, because I've always said, and I believe still to this day, that dynasty trust is the beginning of modern trust law in 1983. For those of you who had to endure law school and be taught the nebulous rule against perpetuities, and then, like me, had to apply it in the law school exam at the end of the semester, which I still have post-traumatic stress disorder over. The reality is that was just an arcane law from England that came over that says that trusts have to end at a time certain. And so we all know what that means now, because this idea of a dynasty trust has become a household name for those of us who do this sort of planning. But I think it's the very beginning, and in the first step towards using trusts and proper trust jurisdiction to save an enormous amount of money in federal taxation. And so we all know how this works generally, but this is just a way to keep a trust to live forever. It endures forever. It removes the mandatory distribution of assets to a subsequent generation. And so taxation across the states is become, so that was sort of the beginning of it all. And where a trust lives, and I love this because we've been talking about this a little bit differently lately. And jurisdiction is a word, situs is a legal word, but what we're talking about now is where a trust lives. And I love this so much because it's differentiating and juxtaposing from where the settler lives. So there's often I get the question, and the attorneys that we work with get these questions. Well, a settler in California, they can't have a South Dakota trust because they live in California. And that's absolutely not true. We're talking about where the trust lives, not where the settler or the beneficiary lives. And we're going to get into that in a little more detail. So a family like the Roy family in succession, for example, and seemingly based in New York, in the New York City area, or maybe Connecticut as well, could have had a trust in South Dakota, Nevada, Delaware, although they lived in the Northeast, as we talked about. We're going to talk about the idea of how where a trust lives matters relative to taxation on undistributed income. And we're going to talk a little bit about capital gains and how where a trust lives can impact the ability to avoid state capital gains taxation. And just the idea of, again, just by selecting the proper jurisdiction, that's the way to do this. So we'll start very briefly to talk about what I just mentioned. So how could the Roy family, for example, avoided state taxation on undistributed income in a trust that they would have been allowed to establish in Delaware, South Dakota, Nevada, or Alaska? And this is one of the most exciting developments in trust law, I think, in the last maybe 50 years, where it was the first, in fact, I think it was one of the first tax cases in the last 50 years. Kastner, it confirms exactly the proposition of if a trust is in a jurisdiction that non-sourced income, so income not sourced by business or not sourced by real estate, but generated by investment income, is not taxed at the state level. And it can't be taxed at the state level by the state of New York or the state of, in this case, North Carolina, which is where Kastner started. Very compelling, very important case, and frankly, supported the proposition and the argument that myself and people like Bill Lipkin and Terry Prendergast in South Dakota and Jonathan Gottman in Florida and Jonathan Lurie in New York City, we all fought for years with this was the way to do this. And we finally received the case from the Supreme Court, a bit of a gift, because it made, and it gave us clarity, and it affirmed and confirmed what we believe to be true, all driven under the Constitution. So again, this idea of where to place the trust is going to be the common theme for the rest of our conversation, and it drives everything we do at Bridgeford and really everything we talk about, because these aren't just clever conversations to have at a cocktail party. These are conversations and planning tools and structures that actually lead to savings that can be shown over multiple generations. Another idea is the concept of an incomplete grantor trust. Little controversial. Some states have abolished them or tried to abolish them, but in most states you still can use them. But it's a simple example, another indication of how just by placing a trust in a state like South Dakota and Nevada, and in placing a business in that trust and in selling the business that usually has a low cost basis, you can save an enormous amount of money. And this has been looked at for many years by the IRS and private letter rulings and supported. And so we continue to see these used very heavily. We continue to be very excited about it. And even in states like New York or California that have outright abolished them, there are still ways to take advantage of a trust in a jurisdiction that doesn't have a state income tax and sell your business within it and still take advantage of the ability to not pay New York state income tax or California state income tax, in particular capital gains tax, and that's simply by making the gift completed as opposed to incompleted. And so we see this, especially with the large exemptions right now. There is still I will believe, ongoing tremendous play right now in terms of the ability to use these trusts to avoid capital gains on low cost basis assets that get sold inside of a trust. Community property trust is just another example of how to use the rules that we've been given. You know, we're not talking about tax evasion here. I think those of you listening to and watching know we don't promote tax evasion, nor do the brilliant lawyers and CPAs we work with around the world. But we are talking about effective tax planning. This is another great concept. And actually, I would argue not used as well or as prolifically, I think, as it should be. I still think there's some learning and education around this. But the community property trust is simply, it only exists in South Dakota, Tennessee, and Alaska, to my knowledge. And simply what it does is it changes the attributes of assets inside of a trust to community property, regardless if the settlers, husband and wife, live in a community property trust state or not. You might be saying, great, David, thanks for the definition. What does it mean practically? It means practically that the death of the first spouse, at that happens, there's 100% step up in basis. Pretty compelling, especially for couples and families, or rather married couples, I guess, that live in a jurisdiction that's not community property. So there's a tremendous tax savings there. And how do we get there? Oh, just simply by looking at the jurisdiction or a jurisdiction that has a codified community property trust. And as I mentioned, there's only 3. I think the 2 leading are South Dakota and Alaska in that order. And I think Tennessee is a little more restrictive. And I think you have to be a Tennessee resident actually to avail yourself of it. But it all comes down to where a trust lives. And I'll say again, has nothing to do with where the settler lives or where the beneficiary lives. So tax planning opportunities, all of which I would have hoped that, you know, in a real life Roy family succession scenario, the planners and lawyers at the table were talking about what you can do with just the right jurisdiction, and what you can do just by looking at the code, the IRS code, and all the various ways that you can properly avoid taxation. And again, I say again, this is not a tax evasion. You know, I believe that anybody who knows the rules of the game of chess better wins. All this is a chess game. We're presented the rules by the IRS, and we are following the rules given to us by the IRS. And it becomes a very exciting way to help our clients plan properly and avoid paying taxation that's unnecessary. And again, I think it's a component of what we would have seen in succession. But now we're going to transition to much more applicable aspects of modern trust law that it was clear to me through the Succession series was lacking and not part of the overall framework for the family by virtue of how it ended in tragedy for them. But this quote really resonates with me. It resonated with me when we first started Bridgeford, and it's clear. I mean, the changes in the last 20 and 30 years far surpass what's happened in the last 2 centuries. And these changes have affected every aspect of how we approach trust planning. I mean, when I was in law school, asset protection didn't exist unless you went to the Cook's Island, and jurisdiction really wasn't an issue because we weren't talking about it very much. I mean, 1983 sounds like a long time ago, but it really isn't that long ago. So up until 1983, trusts had to end, and at the end of the cycle of the perpetuity clause, then an enormous amount of money went to the federal government. It doesn't happen anymore. So this is exciting. And I always chuckle to myself sometimes, and those of you who have known me before Bridgeford and have watched us evolve, I didn't like my trust and estates classes in law school, I say, and laughingly, because I thought it was boring. Now I grew up to own a trust company, and I have become very, very excited about what you can do in this space. I hope all of you listening and watching are excited about what you can do, what we're going to talk about for the remainder, because these are very, very, very compelling planning tools that I know families from not just the United States, but all over the world want. And that's what they're coming to Bridgeford for. And that's what they're coming to you for. They want an answer. And when they're concerned about asset protection, they're going to ask you about domestic asset protection trusts. And talk about one of the most compelling ways of protecting families of wealth from themselves. Here we are. This is probably a great way to begin in terms of really practical applications in this context. And we're not talking about nefarious activity. We're not talking about dealing with bad actors. We're talking about the ability to shield assets from creditors and fraudulent claims often, spouses fraudulent claims often, and it's a way to legally shield assets while the settler receives income, of course. So for those of you who have worked with asset protection trusts, domestic asset protection trusts, you know how well this works. You know that this is a compelling planning tool. And you also know that over the years, the anecdotal how many angels could dance on the head of a pin argument that people would have, particularly at heckling, which I've had a couple of times with maybe some of you even listening, is, well, do they really work? That was always the fun conversation after a few glasses of wine. And the only way you get real asset protection maybe is to go to Nevis or Cook's Island. And even in its early stages, I developed an opinion about it, which really hasn't changed. And I'll get to that opinion in a minute. But the reality is this idea of a domestic asset protection trust and its power in the industry, or rather in its power to protect families, I should say, is remarkable in that there's now case law. Very, very important case law on point that has made it extraordinarily clear that these trusts, if not fraudulent, and we don't deal with fraudulent trusts at Bridgeford, if not fraudulent or subjected to some sort of fraudulent conveyance, then they will be upheld. There's a case out of South Dakota called Cleopatra. A lot of you are aware of it. A lot of you know about it. And it is a blistering opinion from the Supreme Court that made it very clear they were not going to enforce a judgment coming out of a divorce in California. And so we celebrate that case as a way of saying, well, listen, these strategies work. And if nothing else, they provide a deterrent at the end of the day, which is really what we're talking about. There's a case in Delaware at the trial court level, effectively their trial court level, probate court level, that is also stands for a very similar proposition that the court in Delaware said absolutely not. This is a properly established trust in a jurisdiction that has a domestic asset protection statute, and they refuse to pierce it. And I think it gives more support and affirmation for the conversation around asset protection, which I believe we're all entitled to, unequivocally, as long as it's not nefarious or designed to shield people and allow people to provide a fraud on their creditors or a fraud on their spouses. And that's not what we promote at Bridgeford. So the jurisdiction matters from a domestic asset protection. I've already talked about the variances in the states. We have cases now one powerful case out of South Dakota, one out of Delaware. Every state has a little bit of a different nuance to it. Steve Oceans does an amazing job of putting these on a chart. It's an objective chart. I'm going to show you our objective chart here towards the end. But the devil's always in the details here. And the biggest probably comparison point, data point, is the fraudulent conveyance number of years, which is really just a fancy way of saying look back. And so in the industry, South Dakota and Nevada it's 2 years, and it's among the shortest. Delaware's is 4, which is interesting to me that Delaware's even considered a player in the asset protection space, given that they're double the amount of years in terms of a look back. So when I say that, it means it takes double the amount of years for the asset to asset protection, I should say, to actually vest, for lack of a better word. And how do we use these domestic asset protection trusts? And what are different, what's the application in real life, not just to protect from the creditor claims I've talked about, but also we've seen them used in a very compelling way in conjunction with or instead of prenuptial agreements. And so for those of you practicing in this space, prenups from state to state can sometimes be hard to enforce or win a challenge around, because there's so many different peculiarities in terms of what has to be done and recorded and reported and disclosed. And that's not the case with these trusts. So lots of families come to us in particular saying, hey, Jennifer's about to get married. We're not sure we love this guy. She's marrying. We want to make sure that the assets that she's going to have access to are shielded from her proposed spouse, and that is a reasonable request. I mean, I have children, and to the extent that I don't want them to be taken advantage of, this is a tool that families love, and I've seen it work multiple times around the country, and I've seen it talked about everywhere, and I think it's just an aspect of asset protection that we need to keep in mind. Unlike prenups, there's no notice requirement, there's no disclosure requirements, and it just makes for a whole nother aspect of asset protection in that context for premarital planning, which is vital. Something that's talked about a lot, and it's a variation of a domestic asset protection trust. A lot of credit to Steve Oceans. He's been writing a lot about this and talking about this as the thought leader that he is. And this idea of a hybrid it's just a third party trust at the inception. So there's nothing particularly complicated or sexy about it. And it's designed to initially strengthen asset protection. So what I mean by that is the most powerful form of asset protection, probably in the United States at least, is a third party asset protection trust. Because it's not self-settled, and as long as the spendthrift provision is appropriate, they're very, very hard to pierce. And that was really the genesis and the thesis, rather, of that court case in South Dakota that I mentioned, Cleopatra. So it starts out as a third-party trust, but the settler may be added through direction of the trust protector, whom we're going to talk about in a minute, what a trust protector is and why that is essential in our planning process. But the settler can be added as a beneficiary. So it effectively takes a third-party beneficiary trust, third-party beneficiary trust, and turns it into, that's why it's a hybrid. It turns it into the ability that the settler can start to derive an income, which, as we've talked about, they can under the domestic asset protection trust statute. So this is an evolution of the conversation of asset protection, and how does this relate to the Roy family? How does this relate really to succession and some of the horror stories that were depicted in various episodes? Well, it's completely on point. I mean, for those of you who followed the series, there's one storyline where some terrible things happened on a cruise line that they opened, and there was all kinds of concerns that the claims were going to be so big that it could have taken the company out. That's one example where if an asset protection trust was in place, proper planning was in place, probably there would have been a lot less fretting. I know the fretting was probably why people like succession so much, because, it's drama sells. But I think the direct response and answer to that concern about asset protection is an asset protection trust and a domestic asset protection trust. So that's exciting to me to talk about. Another aspect of it from the succession plan show was when one of the sons was going through a very difficult, painful divorce, and there was a reference to the fact that his it may have been his second wife was they were concerned and frustrated with just how much money she was going to extract from the family. And the first thing that went through my head as I was watching it is, well, if there was an asset protection trust in place as part of the premarital planning, either instead of or in conjunction with the prenup, that whole conversation would have been avoided. And so again, I know drama sells, and then maybe the show would have been less interesting. But again, it just highlights how so much of the challenges that have hit that family could have been avoided just by trust law, proper trust law. We can't talk about modern trust law and its opportunities for very high-end planning without referencing the purpose trust. And here's why I say that. And I chuckle because people say, what's the purpose of a purpose trust? But, often when we think of trust planning, it's always and only in the context of planning for a specific class of beneficiaries, next generation, a person, we'll call it a person, or a family member. And it's to protect them from themselves, as we've been talking about. But often families don't want to just take care of, or protect rather, too, next generation and subsequent generations with asset protection trust or with trust planning. They have a purpose. They have an idea that they want to protect, or a concept that they want to fund or promote or defend in some cases. So it's in theory, it's a lot like a charitable trust where it's designed for a charitable purpose. This idea takes away the charity piece and allows us in South Dakota in particular, and other states who have statutes on point and on the books, to take a purpose trust and establish it for a purpose. For example, to take care of a pet is a purpose, right? Or take care of pets generally, or to take care of real estate forever and have it maintained for park status, so people can go and see it. One of the most interesting aspects of purpose trust that we've seen so far is in the cryogenic space, where families or individuals who wish to take advantage of the science of cryogenics and preserve their bodies forever until there's a cure for whatever it is that ended their life. They create a trust called a purpose trust. And the purpose of that trust is to exist and fund something that may happen to the extent that there is a cure found for these individuals. It's a little salacious, and some people get concerned and nervous about it. But the reality is, it's probably the best example of what is a purpose trust. Is this idea of that concept. It's more supporting a concept than a person in that context. Same thing with the family or the pet trusts, and we see them and use them all the time. And we're going to talk about a little bit later the private trust company model, and this is where the purpose trust really becomes interesting and applicable. And so we've already talked about why the use of purpose trusts. Again, only a handful of states have a statute on point. South Dakota has been recognized multiple times as having the most flexible and most detailed, and it works exceedingly well. And I think, like the concept of the marital trust, I think there's more education needed on the power of how these trusts work, and how a purpose trust can really work well in the context of overall planning for families, wanting asset protection and tax planning, but not just to benefit a particular class of beneficiaries, but to benefit a concept and to propel a concept forward forever. So we referenced secrecies earlier. Sydney asked a great question, made a good observation about the Corporate Transparency Act and whether we thought we were going to see that happen again. And I do. Sadly, I do see that happening again, but in some form or fashion. But this idea of secrecy has been blown away, of course, as we know, by the courts and regulation, as it should have been, for sure. And the idea that we're hiding information from the government is not something that Bridgeford endorses or sells at Bridgeford. This idea, it's privacy versus secrecy. This quote really resonates. And as I said earlier, I'm a firm believer that we all are entitled to some semblance of privacy, and it's a tricky balance to get to attain it, which is why I think the Corporate Transparency Act ultimately failed, because multiple courts thought it was just overreaching. So we are fiercely independent in the United States. We are entitled to have privacy, and South Dakota is a very big example of that. But before we get to South Dakota's approach, we want to continue to juxtapose and compare and contrast what we're talking about. Privacy, not secrecy, as I said. Enormously important to families, particularly high net worth families, and particularly families who have achieved a lot over the time frame, especially for athletes and sports stars and entertainers and actors and directors. We do a lot of work in that space, and that's increasing. And one of the biggest concerns they have is privacy. Of course, they want to have notoriety, which is different than maintaining privacy. They're two different ways, and they can coexist. And so again, it's not a secrecy play, it's just a privacy play. And we're excited and passionate about the conversation because again, I've said it multiple times, I just believe it's a right here we have as people as anywhere. Citizens of the world have a right to some semblance of privacy for sure. And just to drill down a little bit more about what I mean in terms of what you get from a privacy conversation perspective in various states. I mentioned South Dakota unequivocally has been recognized as having the strongest privacy provisions in the country, and that's been acknowledged by Trust in the States magazine multiple times. It's been acknowledged by planners from all over the world, and simply because there's various aspects of quiet trust law statutes on the books that allows settlers and trust protectors in particular to determine who even is allowed to know about the existence of the trust, including beneficiaries, which is really interesting to me because so that's somewhat controversial, but actually I think a really good idea. I mean, if little Johnny finds out he's a beneficiary of a trust of $100 million, you think he's going back to Harvard for a second year? Probably not. So this is another way of protecting next generation from themselves and protecting families of wealth from themselves. So let's go back to succession on this point. It was very clear to me that the 4 children knew an awful lot about how much money Logan Roy, the patriarch, was worth. And they knew so much about it that they were jockeying for position and competing with themselves, tearing themselves apart at that generation to be the successor. That's the whole idea of this whole thing is who's gonna take this over. And that created the infighting. And so there's a strong argument to be made. Well, maybe Logan Roy should have put a series of trusts in place, created a quiet trust provision, and not have his kids know so much about his personal net worth and the net worth of the various media conglomerates that he owned all over the world. And if they didn't know that, then the competition probably would have been reduced, and they likely would have not become embroiled with drug addiction and a lot of the terrible depictions that has happened when wealth goes wrong. That's what you see in succession. And I think at its heart, if privacy provisions were put in properly, or using quiet trust, I think so much of this could have been avoided. And I think perhaps the lesson that was inadvertently trying to be taught to the viewers is that Logan Roy was brilliant at building businesses, but wasn't maybe so brilliant at the planning part of it, and in some respects contributed to the destruction of his own family. And I think privacy could have really had a big impact there for sure. So I think as we're talking through this together, I hope that the enthusiasm and the ideas that could have been implemented in that series if it was a real world family, and some people actually suggest it actually is based off of a real world family, but I'm not going to get into that. But if these aspects were implemented of modern trust law, then so much of it could have been avoided. Delaware has some privacy, but it's discretionary and doesn't have a quiet trust statute that I'm aware of. In most states, this information just is accessible to the public. There's no ability to stop a trustee from sharing information about the trust. And so these are the amazing ideas. I like to say big ideas that we bring to the table, and I think could have been a way to avoid so much of what we saw in succession. But to be careful about, I get into the idea of, well, we're not talking about secrecy and we're talking about privacy, but we also have an obligation to honor and protect the integrity of the industry, of course. And I'm very proud of our industry. I collectively, everybody on this that I've noticed, so many people on our viewing list that are listening. I mean, I'm so proud of what we do collectively and in conjunction with each other and in collaboration. But it all kind of turns on proper regulation, and it turns on making sure that we collect the proper KYC, of course. And I know all of you I'm preaching to the proverbial choir here. However, it is important to recognize this, because later on in our conversation, I'm going to directly address the criticism that our industry has had to endure and continues to endure, sort of suggesting that we're nefarious and that we're breaking the law, which we are not. And so this is where we address it head on. South Dakota has very, very specific laws around KYC, which we follow, of course. Everybody follows in South Dakota, as well as other states. And I don't want to lose sight of that. Which brings us to what I believe is the revolutionary aspect of modern trust law, and is the part of modern trust law that has been an absolute game changer. And this is a quote that I found as we were getting ready to do Bridgeford, and getting ready to really get into the idea of explaining and educating and promoting what is the directed trust. The directed trust model is so, and again, a little dramatic, but so revolutionary in the trust industry for so many different reasons. And I think that we want to slow down and talk about it for a couple different reasons. And I think that, one, because other states, lots of states are starting to implement them. It's starting to be codified in various forms. But I want to talk about it in its purest form, conceptually. In its purest form, conceptually, the idea of a directed trust is simply to unbundle aspects of liability. And so we'll talk about its execution in a minute, but let's talk about why the concept is so revolutionary in the trust industry. We all grew up in a trust industry, at least those of us my age, that was bundled, where the assets were managed by a big bank, call it Bank of New York Mellon. And the trust company was also Big Bank, Bank of New York Mellon. And Big Bank, Bank of New York Mellon, also often did lending, of course, did lending and cash management, and in some cases sold insurance and mortgages, and did it all. And for so many years, that model prevailed. So you had asset management and trust activity under the same roof. And so I slow down and belabor that point a bit, because we accepted it for so many years. When I was in law school, that's just the way it was. When I came out of law school and then went into the trust industry, that's just the way it was. But here's the funny thing. Just because it's the way it was, and that's how it evolved, didn't mean it worked. And you know who the first demographic to point that out? The wealthiest families on the planet, particularly in the United States. They started to think, well, I don't want Bank of New York Mellon to manage my money and be my trustee. They can be one or the other, but I don't want them to be both. I don't like that. And they started to say, hey, I don't like the loss of control. I need asset protection. I want privacy. I want these tax advantages, but I don't want to give up control to some trustee in New York City and or worse, outside of the United States. And we're going to get to that point in a minute, in a little while. And so the directed trust model is such an amazing industry response to what had become a problem with the trust industry. When I was young in the trust industry, the complaints were there was too much conflict of interest, because having somebody manage your money and be your trustee seemed weird. It didn't seem to really be something that protected all the interests of the beneficiaries and the settlers in particular. And so the industry responded, and states like South Dakota and Nevada and top-tier trust jurisdictions adopted directed trust models and directed trust statutes. And here's why I'm being so succinct about this. They have statutes on the books. I've heard it said by lawyers in Pennsylvania and other states around the country, where they say, well, yeah, I know what a directed trust is. I can write you one. And I think, well, sure, my example is, you could also say the sky is red if you want to in your trust. But if you don't have statutory authority in that state, then, okay, so how do you enforce it? How do you really protect, the interests that we're trying to get at? And so we need to look to states that actually have a codified director of trust statute, and there's 8 or 9 of them now that have them. And California just passed a version of it, which I think is a little unclear, nebulous. Same with Pennsylvania; they don't seem to outline it as succinctly as I'm about to. So generally speaking, these modern trust law, directed trust structure bifurcates these roles, these fiduciary roles. Those of you who use them that are listening, you know how effective this is in separating decision making and removing, for sure, the conflict of interest, and how the family can put people in control positions, in fiduciary control positions, which is important to point out, that can make important decisions like investment decisions or distribution decisions that in the old days, in traditional bundled model, all happen under one roof, and often by the organization managing the money. And I would say finally that model started to break down. So this does a beautiful job of outlining, in my view, how this all works. I mean, that you have a John Doe Family Trust, Bridgeford Trust Company, or a trust company like ours is the trustee. And then there's a distribution committee that makes distribution decisions. And it can be one or more. It's very flexible and under most of the statutes. You have an investment committee, which is in some cases the heart and soul of the director of trust, because that's what wealthy families are most concerned about. That's what somebody like Logan Roy would have been concerned about in succession. Nobody wants to give up control, of course, particularly over investments. Particularly when you're a first-generation wealth creator and you've built businesses that have been successful all over the world, you don't want to hand that decision-making power to Bank of Mellon or Wells Fargo. You want to retain that. And absolutely that's possible under the directed trust statute. So in this example, Logan Roy didn't need to be afraid of giving up direction and control because he would have been maintained or stayed in a control position and making all of the decision making on that point. And so you see, and for those of you who are hearing this for the first time, or I would say have not used it in your planning, it is an amazing structure, and I'm using as many superlatives as I can because it really is, and it really works well. But more importantly, the families love this structure. They want this structure. It's a more cost-efficient structure, and it works exceedingly well in the idea of bringing all of the advantages that we've talked about so far. You know, the trust planning, as I said. I mean, tax planning and asset protection and privacy. We all want those things, but as I said earlier, but we also don't want to give up control, and this is the way to avoid giving up control.
So there is some criticism, though, on directed trusts because of the amount of control that these families are allowed to maintain. And while the families love it, there's some attorneys that say maybe it won't withstand the courts. So what are your thoughts on that?
Yeah, it's an excellent observation, and it's one that we hear a lot from attorneys around the country, particularly attorneys who just aren't comfortable with it or who have not used this structure yet. And so what Sydney's alluding to is the concern that perhaps a directed trust dilutes fiduciary authority such that it can be considered a sham trust by a court. And for those of you who aren't familiar with what a sham trust is, it's just a kind of a goofy way of saying it's not a real trust, in that if it's not a real trust, then the tax advantages aren't appropriate, the asset protection's not there, and there's no privacy. So it's an important question, Sydney, and it's one I think we should slow down on. I've had this conversation in Hackley multiple times, and it's kind of goes back to what I said earlier about like how many angels could dance on the head of a pin, because there is no court case on this. There is no authority that suggests that a directed trust is a sham trust. And I would suggest, though, in jurisdictions that do not have a statute on point, maybe we're closer to that sham argument. So say we're in Pennsylvania and some attorneys, like I said, well, I can give you a directed trust. I'll just draft it that way. And then the trust is challenged in a Pennsylvania court. I absolutely believe it could be argued that it is, in fact, a sham trust because it's not based on any statutory authority. So as we talk today, the directed trust has not ever been even a challenge that I'm aware of. And there's certainly no case law to suggest that these trusts are anything but solid. The integrity of the planning is succinct and upheld and honored. And I believe even if there were a court challenge, it would succeed. It would succeed. Which brings me to the trust protector. I mentioned earlier, trust protector has the power to make decisions in terms of who knows what about the trust, including and up to even its existence. I'm still amazed at the conversations that we have around the country of how many planners don't embrace the trust protector concept. And if I go back to the schematic that I showed outlining how the directed trust works, you'll see to the left there, in conjunction and at the same level as the trustee, is this concept of a trust protector. I like to call it the super trustee. I think maybe Terry Prendergast was the first to say that. But it is a super trustee because in many respects, perhaps all respects, it has more power than the trust company itself, than Bridgeford itself. So it has the ability to and authority to make vast changes to the trust document. It can replace easily Bridgeford Trust Company or the trustee, and can change situs, and it could change the direction and really flow of the trust in a great way. And when I say great way, I mean modernization way. So many of these trusts need to evolve because life evolves and goals evolve, and sometimes you have beneficiaries who get themselves in trouble, so you need some flexibility around what they get or what they don't get. And so the ability to take these trusts and make them more flexible in terms of how and when authority is executed is extremely, and I use this word a lot, compelling. So when you put this concept together with the directed trust model, it delivers an amazing amount of direction and control. And we talk about it all the time with our families, with the advisors that we serve, many of which still don't use this as much as they probably maybe even should have. We have a podcast series that we call Delivering Direction and Control. And at the end of the day, I guess, that's really what we've been talking about over 50 episodes, is how do you deliver direction and control back to families? And it's always some variation of this theme. Even our most recent one was a big focus on how families need and want direction and control as part of their planning, because they want the benefits for sure. Family advisor is a really interesting concept that is only exists in South Dakota, and it's the idea of sort of lightening up the power or changing up the power a bit of the trust protector. And they'd be thinking, well, why does that matter? Well, it matters because the trust protector is so powerful and is almost always a fiduciary that some don't want that responsibility, because it's an enormous responsibility as a fiduciary to, of course, act in the best interest all the time in all your decisions. So sometimes families would call on, their attorney or their family wealth advisor or their CPA, and they would say, "I want you to be a trust protector." And you know what they would say? "Oh, that's too much liability. I'm not doing that. I don't need that. I don't need your son suing me 6 years from now because I didn't approve a Lamborghini. I don't want that in my life." So South Dakota, as they always have been, leading the way and as thought leaders in terms of how do you come up with a solution to that problem, they created the family advisor, which is essentially a watered down version of the trust protector. As I said already, it only exists in South Dakota. Sometimes it's the reason why people choose South Dakota over other jurisdictions, in Nevada in particular, because they don't have this. In Nevada and South Dakota are so close that there's very few differentiating data points, and this is certainly one of them. So for those of you who say, "Hey, I love the idea of a trust protector, but man, it's just a lot of responsibility. I don't think my brother is going to want to do that," look at the trust protector light. As I said, it gives it's called family advisor. We call it trust protector light. But it just takes away the burden of being subjected to a fiduciary standard, but still gives a fair amount of flexibility in terms of removing the trust company, as I mentioned, and other aspects of control. So again, if you want somebody other than the people named in the directed trust to have influence over the direction and control and administration of the trust, this is a way to do it. A great way to do it. Which, another aspect, going back to succession, that struck me, and maybe this could have been, and it may be maybe the most glaring aspect of what went wrong here. Years ago, when we were starting Bridgeford, I became very, very interested, long before Bridgeford actually, in the idea of family governance. And my good friend Tom Rogerson talks about, legacy planning different than wealth planning, different disciplines, different thinking. Legacy planning, of course, was talking about how to inculcate values and make sure these families don't destroy themselves over multiple generations. Back to the idea again of what we believe we're doing is protecting, families of wealth from themselves with these planning tools. But critical to all of this is family governance. And I have been a big student of how to have open and honest communication, how to coexist with patriarch who is very proud and very much wants to control, but also knows he needs a succession plan and knows he wants to protect his family and knows he doesn't want to see the things that happened to Logan Roy's children. So those who saw the show know how bad that became. And I have to believe every first generation wealth creator doesn't want that to happen to their family. And this is where it's so essential to get involved with family governance matters. I know so many of you listening say, of course, David, of course. But while we may say, of course, we know this and the bullet points, I see it executed so little across the industry and around the world with some of the largest families we work with. And that is not, we particularly don't focus on this as a discipline at Bridgeford to offer to our families. We lean on people like Tom Rogerson and others who are geniuses. And I encourage you, for those of you who want to know more about that discipline, we have a extremely illuminating web podcast with Tom that I think is one of our best, and I would encourage you to look at this. But again, I talk about it because if simply a focus happened for the Roy family on family governance matters, and the tools that are available in the family governance discipline. I mean, for those of you who know this or have participated, it isn't just a fun conversation around the kitchen table. There's a process. There's family meetings. There's a way to do this. There's a way to inculcate family values. There's so many different ways to get the next generation to understand the responsibilities of wealth, the danger of wealth, and really what the opportunities there are with wealth to change the world for good. And so we've missed these opportunities so many times. I can tell you story after story after story of direct, and I use the word calamity. It is. It is calamity to the family. I use the word tragedy. It is a tragedy to see a family that is worth $1 billion by first generation wealth creator, and you see third generation in jail, serious psychiatric problems, drug problems, problems with their relationship, a destructive and ugly relationship with money overall. And these tools, which isn't, and I'm not diminishing, I'm amplifying the importance of it, but the execution of the tools isn't algebra. It's a matter of having open and honest conversations, as I said, and I just think that at the core of what we saw happen in destruction and the downfall ultimately of the family is centered all around this lack of family governance. I mean, if you watch the show, it was full of distrust. Nobody trusted Logan Roy. The four siblings didn't trust each other. The spouses didn't trust anybody, and the next generation kids, they were all playing in the money and didn't know what was going on, and it just created the perfect storm of why the whole thing ended up collapsing. I mean, I'm not suggesting they lost all their money. I'm saying they lost who they were as a family, and whatever goals and aspirations and values were not inculcated, and it just became a toxic, terrible environment. And in succession in this way, I don't think overly dramatize it, because I've seen it directly. We've seen it at Bridgeford. All of you, I'm sure, have seen it in some way or another, and there's just a way to avoid it. And so as I said, I continue to be very passionate about it, and wish that as an industry, we focus more on this. I mean, it's great to have a tax plan, and it's amazing to have asset protection and privacy, and it's also great to give direction and control back to everybody that wants it in the family. But if they all hate each other and don't trust each other and are competing for the gold ring at the end of the day, then what have we really done? What have we really done for the families that we're serving? And I think we haven't served them well if we haven't protected them from that. Which brings me to a private trust company. Very hot topic right now. and it continues to be growing and evolving in terms of evolving, not evolving, but another quiver in the arrow in the quiver, if you will, of how to plan for large families. So we see private trust companies used in conjunction very well with family governance tools and private family offices, single family offices in particular. And so essentially what this is, and I know so many of you know what a family office or what a private trust company is, and it is kind of something that started out of Europe, I think, in its inception. But it's a regulated trust company in a state like South Dakota, Nevada. Wyoming has an approach to it, and it has some less regulation, less capital requirements, and a lot more flexibility for the family. It can only serve one family. That's why it's called a private trust company. And the idea is to, in addition to and it brings all the modern trust law planning tools that are so exciting to us, but it also helps with the inculcation of values. It also helps with the family governance, because you can put second generation on the board of the trust company, and they're going to be actively involved in decision making, and they're going to understand how philanthropy works, and maybe that's something they should be thinking about instead of their next Lamborghini, and the opportunity of what tremendous wealth can bring, and how to execute something positive for the family and the world, and to not lose sight of what we're doing. So we love this concept. I talk about it all the time. We handle these. We handle a number of these at Bridgeford, and it's just a phenomenal family tool.
So before we move on that point, we have a question that came in. And just a reminder to everyone watching, we'd love to answer your questions. But the question is, how large does a family need to be before it makes sense to consider forming a private trust company?
I mean, that's a great question. And I think it may vary a bit. It's a little bit situational, but I would suggest, and it's been suggested to me by attorneys in particular, that probably families that have about $500 million would make sense to start looking at this. And total assets, I'm not saying $500 million of investable assets. I'm saying $500 million in total net worth, because there are costs and fees associated with maintaining the board and regulation and compliance, and all the things that go into running these family office, these private trust companies. And so that is something to consider, and it's something to think about, because it becomes a cost benefit analysis. I mean, if somebody has $500 million of assets and they employ Bridgeford to handle 20 trusts for that individual family, is it more cost efficient and effective for them to start their own private trust company, which, by the way, they control, back to that control and direction aspect of things, and save money, and basically, essentially, get a more malleable model of trust execution inside the family with less cost. So that's a lot of what we see. So about $500 million is I think the general rule of thumb. I certainly happy to talk to people offline and debate it. And I think that when we're talking about trust companies in particular, private trust companies, we have to draw a distinction. And it's a question and a concern that I have had now for a couple of years. I mentioned that Nevada, or rather Wyoming, has an approach to private trust companies. But if you notice, I didn't say it was a positive approach. They have done a very a tremendous job talking about this unregulated trust company model. And so for those of you who have looked at this, you know where I'm going. It's essentially a private trust company that has no regulatory oversight at all, none. And they claim that they can get them set up pretty quickly. And when I first heard this, I thought, well, South Dakota really needs to do this, because it's we want to serve wealthy families. And then I started, kind of put my lawyer hat back on, which admittedly doesn't fit very well anymore. But I started thinking about if we have a $1 billion family that wants asset protection and wants the tax planning and needs the privacy and wants all the direction and control, they probably also want their trust company to run properly. I think we could all agree. And whether we like regulation or not, that is what regulation does, is make sure that we are operating properly. Bridgeford just came through another regulatory exam, and we're bruised and battered, but better for it. And I say that with all sincerity. It's a painful process, but it's a necessary one. So when the concept is sold to $1 billion family. No, you don't need your trust company regulated. Okay, so how do you know then, if if a creditor ever comes, that the trusts are being administered correctly, or that the filings are being done appropriately, or that um, the right people are signing the checks? I mean, that's what regulation is. And again, there's always this debate: too much regulation, not enough regulation. I don't want to get in that political conversation. I'm saying this business is a relationship business, and we have to get it right. So, I always say to lawyers and everybody that we talk to when asked, I mean, all of this amazing planning is only as good as its execution. So also, when you're choosing a trust company, you have to make sure they know how to handle these things, of course. But if you choose a jurisdiction where there's no oversight at all over a private trust company, to me, it becomes dangerous. It's not the right approach, we don't embrace it for those reasons. And I think if you think through it carefully, that's the answer. And here's the counter argument that we get all the time. Well, but private trust company that's not regulated in Wyoming, there's more privacy because nobody knows about the existence of the trusts, and the government, the big bad government, doesn't regulate them, so the government officials don't know about it. And I just think that's the wrong argument for a couple of reasons. One, there's not been a single instance of a government body or regulatory body in the trust space in the United States where information was stolen, leaked, or otherwise sold to nefarious people. So I don't think that works. I think that's a scare tactic, especially for families in Latin America who unfortunately live under that fear. That doesn't happen in the United States. And so to suggest that we can't oversee a trust company, that Wyoming as a state shouldn't oversee a trust company because the Wyoming state, that's essentially saying that the state of Wyoming in itself is corrupt then because, well, they can't be trusted to regulate a trust company, which to me is outrageous. And I don't mean to offend anybody listening who loves the Wyoming model, but at the end of the day, I'm happy to debate it. I don't think it's the right solution.
So, David, I was hoping that you could speak a little bit on what a corporate trustee actually does in these private trust company structures.
Yeah, that's a really good point, because that's sometimes it gets lost in the translation here. Trust companies like Bridgeford and others across the state of South Dakota and Nevada, and other jurisdictions that have the statutes on the books, what they do for the families that want them is provide the regulatory compliance piece. So we take them through the compliance process and ensure that they have the policies and procedures manual in place, and ensure they have the BSA regulations correct, and their onboarding and KYC. It's the magic of how trust companies operate fundamentally from a compliance perspective. So that is the first really aspect, Sydney, of what happens at a private trust company at the trust level, the trust company level. And then trust company always provides board members because we have to have jurisdiction situs properly where the trust lives, as we've been saying lately. And if the trust is living properly in South Dakota, then you're going to need South Dakota board members. That's what we provide. Aspects of trust administration have to happen in South Dakota or Nevada or Wyoming. That's what the trust company also can and should provide. So it's really a three-legged stool, I suppose, of compliance, regulation, board activity, and the actual execution itself. And works exceedingly well. That's a part of the work we do at Bridgeford. We love everything we do at Bridgeford. This gets to the heart of family governance. This gets to the heart of working with family offices. And this is just a tremendous education tool that, again, brings direction and control to families. And again, you can only get in the right jurisdiction. So it goes back to the theme of, yeah, we love all these concepts, but you can't get them in Pennsylvania, New York, California for sure. So when we're looking at all this, we have to remember that you have to find the right jurisdiction and the right approach. So you might be saying, well, David, all this is great. And I have a ton of clients who may or may not like this, but their trusts are in place, and they're beneficiaries of trusts that have been in place since the dawning of time, and they're convoluted, and they're broken, and they're stale, and they don't execute the way they're supposed to. And so there's really nothing I could do about it. I really would love to get them into South Dakota. And here's the answer. A lot of you know, because especially those who've been following Bridgeford, we love this concept. We think it's another amazing evolution of modern trust law and another way to deliver direction and control to families. And this is how you take a tired and old trust and turn it into a modernized trust that brings in the very best of what is modern trust law today. And so the idea of decanting is crazy enough. As much as I've been critical of the state of New York, they were the first state, I believe, to adopt a decanting statute. But then along came South Dakota and other states who just did it a lot better. And you might be saying, what do I mean by being a lot better? Unequivocally, South Dakota's decanting statute is the most permissive. It's the most expansive and flexible, and allows for an enormous amount of change to happen in an old trust to turn into a new modernized trust. And so this is the answer for families who say, well, I'm at the mercy of Bank of New York Mellon. I can't leave. I can't go anywhere. It's domiciled in New York State or California. And hey, it is what it is. And I say, no, it is not is what it is. It is what it doesn't, it can be what you want it to be. And that is the beauty of what we're talking about. So decanting, I sometimes refer to it as the nuclear option. It's a way to pour an old tired trust into a new one. Some people, and I think it's Steve Oceans, refers to it as a do-over. And it works exceedingly well. Again, South Dakota's has the most flexibility, and it really is, I hate the word game changer, but it's two words, so I hate the phrase. It applies here, and here's why. Remember I was talking about earlier, this idea of rigidity, and the Bank of New York Mellon bundled model didn't work because people wanted more direction and control and conflict of interest, and just didn't want to have to deal with the conglomerate, which we're going to talk about that in a minute. And so this is another way of saying to our families, you have a lot more direction and control than you did. This didn't exist when I was in law school. So it goes to the very heart of what is an irrevocable trust. Everything I've talked about goes to the heart of what is an irrevocable trust. I mean, I'm not going to define it. We all know what that is. It's a trust that can't be revoked. That's not where I'm going. What we have perceived to be how irrevocable trusts work: rigid, expensive, unchangeable, unmovable. That has been true up until about 25, 30 years ago. Maybe not that long. Now they are flexible, movable, cost efficient, not rigid. And this is another tool that makes sure that's the case. So when you add all of these up, I argue, and have argued a couple times, and some of the things we've written, that I believe the perception of irrevocable trust is shattered, and that we in the industry have an obligation to educate and explain, look, irrevocable trusts aren't scary. You're not going to lose direction and control. You're not going to be able to, you're not locked in. You can make changes throughout the years. There's also a very powerful modification statute in South Dakota, which you don't even you don't have to go to court for. Actually, in certain circumstances for decanting in South Dakota, you don't have to go to court. In some cases, in all cases in South Dakota, you don't even need to notify the beneficiaries of the decant. Now that gets tricky, and we have to be careful though, but South Dakota has made it so flexible that you can make changes, do a decant, not go to court, and also not have to notify beneficiaries. Again, all very, very powerful aspects. And decanting, just like asset protection and directed trusts and privacy, it varies by jurisdiction. I've said, and it isn't me that says it, it's Steve Oceans and others who I've mentioned a few times through his chart in comparisons, that decanting is the strongest and most flexible in South Dakota. It's been rated number one now for, I don't know, 6-7 years in a row. And there will be a citation of that chart later, and what we've put together is a comparison chart. So decanting is extremely important as a modern trust law tool, which brings me to the comparative data chart that we've put together, citing people like Steve Oceans and others. But here is our guiding principle at Bridgeford. And I know this should be our guiding principle industry-wide. And I actually think there's authority for that, and we're going to get to that in a second. But unequivocally, the choice of a state in which to establish a trust is as critical as the decision to create one. If nothing else has been clear up until this point about what it is we are excited about as I believe thought leaders and doing the very best for our families, it's the vital importance of jurisdiction. Not just David Warren's opinion or Sydney's opinion or the opinion of anybody in South Dakota or Nevada, because we again, it gets into how many angels could dance on the head of a pin. So we decided many years ago, well, how about we just come up with an objective chart? Why do we have to debate this? I chuckle. We did a jurisdiction showdown kind of a funny title, but that's what it was. Many years ago in Southern California, it was in San Diego. And I was on it. Crawford from Crawford Trust Company was there. Great guy, Greg Crawford and others. And we're getting this discussion. And as we're preparing, I'm thinking, well, this really isn't a debate. I mean, there are facts that are facts. I mean, despite the world we live in today, I guess facts aren't facts anymore. You just say whatever you want. But I still believe that there's objectivity, and this is it. So I took the position somewhat as controversial when it came to me to talk about the debate. I said, well, there really isn't a debate. If you look at the resources and if you look at the data, it's kind of clear who are at least the top two jurisdictions. And I would argue it's Nevada and South Dakota unequivocally. I believe that lots of others would agree with me. And again, I don't think we need to debate this at cocktail parties or at receptions at heckling in January every year, because it's a waste of time. If you just go to the data and you go to objective comparison, and here it is. I mean, you can look and see which state has been ranked number one, for over 10 years by Steve Ocean's, again, a reference. Well, it's South Dakota. That's a fact. I didn't make that up. The citation's right there. You can look it up for yourself. So it isn't my opinion, and it isn't some tweet that I'm putting out there and telling everybody that's true or not. The same thing with community property trusts. I told you how compelling they are and how amazing they are. Well, I mean, it's a fact that they only exist in South Dakota or in Nevada. I mean, South Dakota, Alaska, and Tennessee. But it's also a fact that South Dakota is the most robust in terms of its ability to work with families. And just a couple other data points. Did it go down? Oh, hit the wrong button. Here we go. Amazing. It took me this long to hit the wrong button after all these minutes. I'm decanting. I told you it's a fact that South Dakota has been rated number one. And again, I'm not making this up. This isn't fake news, ladies and gentlemen. Trust privacy provisions. Yes, this Trust in the States magazine, year over year, says South Dakota has the number one privacy provisions. Special purpose entity, I didn't get into it. It's a very interesting nuance in the concept of directed trust. If you'd like more information, let me know. But also, only the state in the country that has it codified, and it's a way to protect people in fiduciary positions. Family advisor, I've already mentioned, it only exists in South Dakota. Fiscal health is hugely important. It's a data point, and it goes to, well, if you're going to take a bet on a jurisdiction because somebody told you at a cocktail reception somewhere that a particular jurisdiction is great. Well, I think you want to make sure that jurisdiction is still going to remain strong from a fiscal health perspective. And you might be saying, why, David? Well, because you want to wake up one day and all of a sudden the state got itself in trouble financially and has to start taxing trusts, or start not just taxing trusts, but implementing an income tax, which is the whole play of going to a non-income income. We say this too quickly. A state that doesn't have an income tax. How's that? It's more clear. So which brings me to the objective and not subjective. So let's just agree with me for a moment, please. Humor me. If you believe that we can objectively determine the top two trust jurisdictions or the best trust jurisdictions, then wouldn't it then follow that we would have a duty as fiduciaries to use trusts in those jurisdictions? Wouldn't it seem logical that we as trustees and we as planners, if we know that states don't have an income tax, certain states allow trusts to live forever, certain states have asset protection, certain states have privacy, and we don't move to put assets in a jurisdiction that has those attributes, could that be considered a breach of our fiduciary duty? Well, I would tell you, I think the answer might be yes. Not because I want it to be, but because I think empirically it is yes. We can look these up, ourselves. I can send you citations, that outline this. These were all things I looked at in law school, and at the time, because I told you I didn't like this stuff in law school, didn't pay much attention. But as we evolved and I was going to different seminars and participated on different panels with people, I heard this concept of, well, wait a minute, if you just look to the Uniform Probate Code, Restatement 3rd, Scots on Trust, I'll get to the case in a minute. Each one of those seminal works around how trustees are supposed to operate all reference some duty to best protect the assets And if if the answer to that question is how best to protect the assets means they should be in South Dakota, Nevada, or another top tier trust jurisdiction, then you violated a fiduciary duty by not doing that. So it isn't anecdotal. I mean, we can weave together an argument, which I am almost certain will be presented to a court in this fashion, that a fiduciary committed some form of malpractice because the trust company jurisdiction was New Jersey. Well, why would a New Jersey trust company say that trust needs to go to South Dakota, Nevada? Well, I don't know. I think it's because they have a fiduciary duty to do so. Do they have an economic incentive to do that? No. Oh man, that's that conflict of interest thing again, isn't it? So I am adamant. I'm passionate about this, and it's not just because of my position and our work we're doing at Bridgeford in South Dakota. I think regardless of who I am and what I represent, we have a broader obligation to the clients that we serve and the families we serve. And if we belong in a jurisdiction that has better asset protection laws and an ability to do all the things I've been talking about, then absolutely and unequivocally, we're in a situation where I think there could be a fiduciary duty. Now I'm going to use a scary word, especially for our attorney friends in the group. Well, CPA. There's a case out of Massachusetts that you see the citation that talked about in some say hyperbole, others in law will say dicta. It talks about the idea of not placing a trust, in this case, putting a Massachusetts trust in South Dakota or Delaware, Nevada, or wherever that has better laws and protection and tax favorable positions, that it's malpractice. It could be considered malpractice. I first thought about this. Bridgeford didn't even have a name yet, and I had left my position at a big bank and was doing a lot of research, and some of these quotes came from that research back in 2010, 2011, and there was a Harvard Law Review article I read that asked that question right on point. And it said, could it be argued, could it be argued? And I think not only could it be argued, I think it could be won in court. So I don't say that to be inflammatory, and I never like promoting ideas based on fear. But I like talking about ideas based on fact. And this is fact. And I don't think we can ignore it. And I think it's only going to become more prevalent as we continue to evolve as an industry. And we're going to talk about our industry as we end. But let's just round out the lessons of succession. Because again, I became so wildly enthusiastic about the show. Every episode a light bulb went off and said, wow, could have been avoided, and this is such a great series, and the writing is so great. But I really started to drill down on it was hitting issues that were near and dear to my heart, which is why we did the whole series. If you haven't seen it, we've written all year long on various aspects. Everything that I hit on has been written on in detail in our blog post. So you certainly take a look at that. And, it's a little more detailed than I'm going over today. And it's been a pleasure to do it because it was just a beautiful roadmap of the relevance of our industry to protect families like the Roy family from themselves. And that's the message of our conversation today, but also what we stand for at Bridgeford, and I think our entire industry should stand for, quite honestly. So one of the aspects, though, that I have to comment on before closing us out is there's a real interesting irony here. I've just spent the last hour talking about how excited we are about modern trust law and all the amazing planning that we're able to do. And I talked about how some of this sometimes can be controversial. And it actually has become. Articles have been in The Atlantic, New York Times, and other publications that have suggested that our industry is nefarious, in that we are aiding, abetting rich people, and we're committing tax evasion, or I should say aiding and abetting tax evasion. Said earlier, asset protection to nefarious people. And that is not all. That's not at all we're doing. And I talked about the chess analogy, but where I really want to go as we come to the conclusion is to remind us just how virtuous our industry is. And the show Succession unequivocally makes that point. We protect families from themselves. And that is good work. Again, it's virtuous. I think we should be proud of it. I don't think we should be embarrassed about what we do. I think we should promote it. I think we should be a bit defensive and just remind people, watch Succession. You don't think what we're doing is important for families? Watch Succession. You'll see just how awful it can become when families don't have this kind of planning. So I like to sort of wind down. Of course, happy to take questions if there's any questions. But one of the things that I think we can't ignore in our industry is what's happening in terms of its evolution. So I've talked about the evolution of modern trust law now for a long time. So let's talk about ourselves for a minute. Let's talk about where the industry is going. I talked to you earlier about the idea that trust companies in the industry, or rather the industry, evolved into a conflict-free approach because families didn't like the conflict. So we're talking about the Bank Mellons of the world and the Wells Fargo's of the world. So then beautifully and magically and appropriately, trust companies popped up in South Dakota in particular, but also Delaware and Nevada and top-tier trust jurisdiction that were independent. They didn't manage money. They didn't do banking services. They were trust companies only. And they solved they solved the conflict of interest problem. That's why we started Bridgeford. I saw conflict of interest firsthand. And so we're proud of that, and we're proud of that evolution. But if we're watching closely and we're paying attention to what's happening in the industry, not fake news, again, some of the biggest independent trust company forefathers of our industry have been taken out by international firms, always fueled by private equity. I mean, in the last 6 months, it's actually astonishing to see how many have been taken out. And, congratulations. I think it's great that they have done well, the founders, and they have done a great job. But what I worry about is the incongruency with paradigm and mission. Because the very reason why Bridgeford started and all those other companies started was to solve a problem in the industry. And I've already outlined it, conflict of interest and all the things. And then, though, how do we explain to our clients that we're no longer independent? I mean, it's like the answer to the problem. We gave the answer. Now we're part of the problem again. Not Bridgeford, but we're part of the problem again. And industry, I think, is going in a very dangerous direction. I think we could agree the CPA direction, and it maybe also be going in a very similar direction. And so this institutionalization of the trust industry is not good for the end user. It's proven time and time again. I lived in an institutional world. That's why we started Bridgeford, and I'm very concerned about it. And I'm shocked. The fact that Bridgeford Trust Company is the oldest and largest independently privately held trust company in South Dakota, maybe soon to be in the United States, the way things are going, is astonishing to me and something I'm proud of, but I'm also appalled at the same time because we exist for a very particular reason, and it isn't just to make money. And I don't mean to offend anybody by saying that. We're also here to do the best we can, and that's not a punchline. We're here to serve the families from a fiduciary perspective by doing the best in what's in their best interest. Again, not a punchline at a cocktail party. That's why we exist. That's why the fiduciary standard was even established in the first place. So I'm concerned about the evolution, which is why independence matters so much. This is why Bridgeford is so adamantly and fiercely independent, and we're going to remain fierce independent. And being big enough to matter, small enough to care is all about why we exist. The integrity of the industry, in my opinion, depends on it. We at Bridgeford, and I know so many of you, are so proud of what we do. We shouldn't have to be apologists for it. And as I wrap up, I'm going to thank Sydney for kicking us off, and she's gonna end it for us. And some of you might be saying finally, but really, so many of you that hopefully that you're still with us. We can't thank you enough for the support you've given us over the years. I use the word a lot, but I mean it. I'm humbled. At over $20 billion in assets, we couldn't have been there and gotten there without all of your support and all the things you've taught me. I mean, I saw the names that signed up for this, and they're mentors of mine who took the time to teach me what an asset protection trust law is and the incomplete non-grantor trust is. So thank you all for your support. Wish you all an extraordinarily happy holidays, and thanks for joining, and hopefully you stuck with us for the full 90 minutes.
Thank you so much, David, and thank you so much for everyone that stuck with us and watched, and for letting us share our passion with you about modern trust law. And we hope that you stay connected with us on our blog, and we'll also have this live stream posted on there if you ever want to go back and rewatch it. So thank you so much, and we hope to be in contact with you all soon.